Nothing on the show is to be construed as legal advice. The contents of this show are for informational purposes only.
Hi there, welcome to another episode of our podcast and YouTube channel at Advanced Resolution Management. I am Abbas Kazerounian, one of the owners, but we have a phenomenal panel for you today. We've got two former justices of the Supreme Court. We've got Justice Nancy Saitta and Justice Nancy Becker. And of course, the former Chief Judge of the District Court. We've got David Barker as well. Hello, judges, and thank you for being here.
Good afternoon.
We've got a really interesting topic today, and I find it fascinating from a litigator's point of view. I find it fascinating from a ADR perspective, a company like ours that offers it. But it's a kind of a novel concept, which is private trials. And I want to start with the two former justices of the Supreme Court that brought this about. I think it was either, during your tenure, possibly, where private trials were made available in the state of Nevada. So if you could, first of all, let us and our audience know what a private trial is and its legality and, how it applies in the state of Nevada for litigants. Maybe start with, Justice Saitta.
I think that the change that was established by and through the court had as much to do with the realization that the caseload was exploding in our urban jurisdictions, and that parties may, at some point in time, need to find a different way to get to the end of their cases. And so the alternative rules, trial rules, were created by administrative order. They were, of course, made a part of the statutory scheme. We now have rules that allow for us to convene a trial that is very much like a regular trial, if you will, except that the judge is created outside of the district court system with certain criteria establishing what qualifications that person needs to bring to the process.
Thank you. And Justice Becker, before we move on, a little bit further, do you have anything to add? I mean, just so that we can, bring this full circle. This is a legally binding trial that you can have in private, right?
Correct. So it's part of the several methods of being able to resolve your cases, alternate methods. And so instead of having a trial in a public setting that's paid for by the government, the parties agree that they would prefer to do a private trial. They pay for the costs of the trial, and it allows them to decide how they want to do it. Do they want jurors? How many jurors? How long is the trial going to be? What kind of discovery that you have? So it's a manner in which you can get to court faster because you are not competing with hundreds of other cases in the public system. And so that's why it's called a private trial.
Interesting. Judge Barker, so is this something that you would commence right from the get-go at the pleading stage? You would go and say, I want to plead my case at, let's say, Advanced Resolution Management, for example, that offers private trials? Or is this something where you're already in the system, in the court system, and then you try and stipulate out of it into a private trial setting?
I can see that happening either way, frankly, but right now with the realities that we're all dealing with, what has been a congested calendar and docket in Nevada is going to get incredibly more so as a function of the fact that we haven't been functional for the last 2 months. Right. So in the short term, I can see a value to litigants who were anticipating a decision before the end of calendar 20, no longer having that potential outcome. But if they come this direction on a private action or turn it into a private action, they can actually get to a fair decision based upon merit and law.
Interesting. And all three of you have served on the district court and have been trial judges. And so when you get a holdup and kind of a bottleneck of 2 to 3 months where there's no civil trials going forward, what kind of domino effect is that going to have on the court system?
Frankly, it's going to be even worse than just the civil docket, because right now, under the most recent administrative order, there's going to be a priority when our courts eventually, they will open and they will get back to full-time work. But the focus and intent for the court for the foreseeable future would be deal with those cases in a criminal, on the criminal side, who have been waiting for their day. And you have dozens, if not hundreds, of individuals who have had a trial delayed and their criminal due process rights stalled as a function of our challenges, who are going to have first priority by administrative order. The current chief judge has already said that we will, or the courts will, deal with those issues first. And so you can anticipate or reasonably believe that between now and the end of calendar 20, the focus of the courts will be largely on, if we have to do a trial, it will be largely on those individuals who have invoked their right to a trial and have that necessary priority. So if you're a civil litigant looking for a decision, you should be planning on a 2021 trial date. And that's the reason, again, I see that as one of the primary drivers for people who need answers now.
Sure.
With no significant, if the agreement is made, there's no significant reduction in the ability to file an appeal or suspend the rules of evidence, and again, unless that's agreed upon by the parties. They can get to that fair decision much more quickly.
Okay. That's interesting. And so, like, just to kind of round that issue up. So if you were going to get on the trial calendar, or as in Nevada, they call the stack, in, let's say, April or May, it's very much conceivable that you're going to have to wait one full calendar year before you get a trial, potentially, in a civil context.
It's all going to depend
Easily.
on the yes. Wouldn't you, justices, wouldn't you agree?
Yes,
Absolutely.
you have to give priority to the criminal cases.
Well, yeah, I mean, obviously, I mean, constitutionally, that absolutely makes sense. But I think even in the civil context, where people are relying on potential money that they think getting to be made whole because they're injured, or in a business dispute, they're relying on that money or something like that, that can have detrimental effect for people in having to wait for that much longer when they've already been in litigation 2-3 years, right?
Absolutely.
I would also add, Abbas, that it's not just getting to trial. Many of the discovery processes that we need in order to stay on the litigation track are certainly going to be affected by the health emergency that we face. And so any trial readiness that someone might be looking at, whether or not they have had an April or May or June trial setting, that is also going to be stalled. And so I think that there's a significant process shift that all parties in the system are going to have to look at in order to get their cases resolved.
Wow.
And this just isn't something that comes about because of COVID-19. The rule and the ability to have a private trial has been around for years, because even without this medical emergency, courts are very backed up, and civil calendars always come behind criminal calendars. So the whole point was that instead of having a 2 to 3 year wait to get a civil case tried, you could do it more quickly. Now you might be looking at a 3 to 4 year wait because of the backup and how long it's going to take each of those trials to clear the system.
I think you bring up a really good topic there, because I mean, let's just take mediations and arbitrations, for example. It was on one of our on the last episode where we discussed that. I think most litigators and lawyers generally, it's in our nature, we don't like change very much. And I think, but for the COVID-19 pandemic, it would not have been likely that most litigants would have been utilizing kind of video conferencing technologies to conduct mediations, for example. But as we have learned over the last 30, 45 days, is that it's actually been quite effective. The results on the settlements at ARM, for example, haven't, I don't think, fluctuated. In fact, I think we're actually settling more cases, which is surprising to me. So I would hope that after COVID-19, even though I think, even as a litigator, I prefer to be there in person to try and mediate a case, we learn some lessons and try and incorporate maybe some video conferencing and some of the other technologies that we've been using in conjunction with in-person mediations. And I think in Nevada, where we've got such a useful tool available, a rule that was written by the Supreme Court over there, underused. I think right now, because of the COVID issue, maybe people will utilize this, private trial system, and perhaps after it's over, again, try and utilize that if the case is right for it. Because I think it is case specific, because there are certain types of case I would envision you wouldn't want to use that. But there are a lot of cases where you would. And I think as lawyers and, in the legal community, I think we have to learn. I think the big lesson is we should be more kind of flexible to change our ways and not wait for a pandemic or something this significant to then change our ways, because I think we could be improving our practices and the way that you as neutrals or as judges, do go about your business. And I think the lesson is we have to start thinking outside the box, generally speaking, anyway. But going back to the kind of educating our viewers and listeners about this, Justice Becker, do you maintain your appellate rights by going into the private sector for your trial?
Absolutely. The way the rules are written, the default is that you have a trial in front of a judge that the parties agree to, and whatever decision that judge enters, or if it's a jury trial, the jury verdict is appealable just like any other case in the system to the Nevada Supreme Court. Now, of course, you can stipulate the parties to waive their right to appeal. That's why private trials are so attractive, because it's the parties who control the process, and they can tailor it to meet their needs and their budgets. But yes, you have an absolute right to appeal, and the rules of appellate procedure and how the Nevada Supreme Court will look, or the Nevada Court of Appeals will look at it, it's entirely the same. That doesn't change at all.
Justice Saitta, who can anybody preside over a private trial, or are there specific rules to that?
No, in fact, there are specific rules set forth again in the provisions that were created by the court. You have to be, and I'm reading directly from this, you have to be a senior justice, a senior district judge, a person who has previously served as a Supreme Court justice for at least 4 consecutive years. So indeed, you will have the ability, I think, the beauty of the rule is that you will be appearing in front of someone who has trial experience under their belt. And just to add to what Justice Becker said, what she described is the perfect storm. This is a situation where you get certainly a more immediate case resolution. You are appearing in front of seasoned, experienced judicial officers. You can take your case and mold it into exactly what you need. Number of jurors, again, stipulating around the appellate process if you choose. And I just want to be sure that the term private isn't somehow confused with behind closed doors. These trials are still, in fact, open to the public. There is nothing truly private about them, other than, as Nancy said earlier, the government isn't paying for it. The parties are paying for the process. But other than that, I think it is highly efficient, and given pandemic or otherwise, certainly an efficient way to get a case towards resolution.
Thank you. So, Judge Barker, let me give you a two-tiered question, and the second part, maybe the other judges would like to jump in. The first part is, if you are a sitting district judge with a case in front of you, and the participants come in and want to remove the case through stipulation pursuant to the rule that Justice Saitta quoted a little bit earlier, what are you looking for in that document in order to be able to grant that request? And the second part of the question, which is, I guess, to all of you, is, do you think that you're going to get any pushback from the district judges for people wanting to go to private trials?
First part of the question is, if I, as a sitting judge, when I was a full-time sitting judge, had a stipulation between litigants that a matter would be referred to private decision, I'd sign that order because it's just one less that I have to pay attention to. It's just one of that 15 for the week that I can mark off as done and report to the Supreme Court complete. So I can't imagine a judge down there. It'd have to be an extraordinary circumstance where any judge would get in the way of the litigants, because the primary ethos in this court, it's been my experience over years, is we're there to help settle disputes, and it's their dispute. Everybody wants their day, and our role is to make sure they get a fair answer. And if they choose to go to private, then God bless, go.
Are you all in agreement with that?
Absolutely.
Hearty agreement, yes.
So let me, I'm not sure what you all think about this. I'm going to open it up to all of you. What, if any, are the major differences between an arbitration and a private trial, apart from the appeal process that is available to you?
Well, you can't get a jury trial in an arbitration.
There is that.
So it's going to be either a one-person decision, or you can have a panel of arbitrators, but there would be no opportunity for a jury.
Understood.
That's one. And I'll turn it over to my colleagues.
You would also not necessarily in an arbitration be restricted to a former judicial officer. Arbitration can be convened with just attorneys. And I caution when I say just attorneys, judicial officer versus practicing attorney.
Very good.
And in fact, in an arbitration, you don't even have to have attorneys. Some arbitrations use specialized panels of non-attorney experts if it's a very unusual set of facts that the parties want people in the field to decide. So
Right.
The standard of review and appeal would be different as well from an arbitration as opposed from the trial.
Right.
And the rules of evidence. I've found that sometimes the litigants will approach an arbitration with a difference in understanding on how the evidence rules will apply, and are sometimes disappointed, or with that lack of understanding stepping into that role, find themselves in conflict on what rules of evidence, if any, are actually applicable.
Sure.
And in Las Vegas, with our rules set currently at a fairly high level for exempting out of arbitration, you could go to private trial for a case that would normally be compelled to arbitration if you want a jury to make that ultimate decision.
Yeah, interesting.
I
mean, I would assume that in a, and it is an assumption, I don't know this, like in a private trial, the jurist is more inclined to follow the rules of evidence strictly than in an arbitration setting, especially if it's a jury trial.
I think it's fair to say that the default rules contemplate using the rules of evidence more strictly than they do in an arbitration. Again, in a private trial, you could agree to relax the rules, but in an arbitration, it's presumed they're relaxed. In a private trial, it's presumed they are not relaxed.
Right. And then with the private trial, how do you maintain a record? I mean, is that up to the parties, or is there a specific way that you have to maintain the records?
Well, I think I don't mean to jump, but there's a courtroom available in the middle of advanced resolution management, I think, just waiting to turn on the technology, isn't there?
Well, I mean, you're actually one step ahead of me. That was, my next question is like, can we do it through like audio? I mean, because I know that the court system is using, I think, is it Jabs or Blue Jeans right now in Nevada, and the audio. Can the party stipulate to use the audio as a as the official record, or do they need to have a stenographer, for example?
All of that can be controlled, again, emphasizing what I think is the key to this private process or alternative process, is that the parties can agree to however they want this to look. On the other hand, the rule itself contemplates if we want to set up an exemplar courtroom in the ARM courtroom, for instance, the parties can pay, in fact, are compelled to pay for a court reporter, a court clerk, a bailiff, if in fact that was necessary. And I guess the beauty of having this courtroom available to us in this time of need for alternative means of case resolution is, given the technology that's in that courtroom, we don't even need to bring everybody together. We can do some of it, witness testimony or otherwise, remote. And so it is actually the best of all possible circumstances in terms of availability, efficiency, and immediacy.
And that's a really good transition with the remote witnesses and everything. We find ourselves in the position that we're in right now during this pandemic. And, we have a clogged up court system that are not doing any jury trials right now, or any civil trials, period. Can you, is it possible for parties to do a private trial through Blue Jeans technology, which is ARM, what we use for the mediations and the arbitrations right now, very, very successfully. And I know the technology can do it, but legally, can the parties do it through virtual technology?
I don't see any reason why they could not. Again, the parties can stipulate to anything. So if they wish to stipulate to use a particular program and to have that program be the record in the case, the only issue that they'll have is that at some point when they do the appeal, someone will have to transcribe that video proceeding and create a written transcript, because the Nevada Supreme Court does not accept video transcripts at this point in time. And that would be it, but that's no different than in the district court. The same thing occurs there when they record the trial. So I could see that you can do an entire trial virtually. Whether you choose to do so is really how you feel about the rapport that you want a witness to have with a jury if you're doing a jury. If it's a bench trial, you don't worry about that as much, I think.
Well, interestingly, at ARM, I'm not sure if people are aware, for the virtual arbitrations, or if it's a private trial, we have the capability to have a concurrent transcript as the trial is going. Now, that's not the final version; it's about 80% accurate, but it gets polished up. I mean, the parties have the choice to say, you know what, we'll just order the written transcript after the fact, which will be more accurate. But if they want a concurrent, like verbal, which will probably help the jurist as well. It's an additional fee, but it's very useful. You can have it concurrently running as you're talking. So that is an available product that we do offer. But you're absolutely right. If that's not something that somebody wants to pay the premium on, they can certainly get the transcript after the fact. And for the purposes of appeal, that would certainly help. Now, but and also if they wanted a stenographer live, I mean, they could have a stenographer live that appears on a channel as well. So I don't think that that's going to be a hindrance either. What about juries on a blue gene technology? I mean, does that create problems?
I don't know. Honestly, I don't know how you bring a jury in remote.
Right, me neither. Because how do you keep control of them?
Yeah,
Looking
well,
things up on
well,
Google, like looking.
Yeah, I don't know. Because there's so many forces that you can't control, and I guess I'm just an old dog. I can see remote testimony, I can see remote a lot of things, but I want to be in the room when those people are listening to testimony, and I would think the lawyers would be too. But I'm not saying no. I don't. And my colleagues are more up on the rules, but I would wonder. I'd have to ponder that.
I think you'd have to look at it carefully, because jury deliberations are intended to be confidential. And so if you're going to try and do that virtually, you have no idea who is in that room with that juror that you can't see, that might be listening in or influencing that juror. So I think that it's probably wise that the jury be in one location and they can all view at the same time and with the same quality, because each person has a different platform. So, and that's important. You don't want a juror coming in on a platform that cuts in and out. Or, as we know right now, if people aren't muting and they have other things going on in the background, like their kids or their dog or their whatever is going on in their houses, they're trying to work from home, that really impacts the quality of the video and the audio. So I would be inclined to think that's not something that would be done easily and without a great deal of exploration on what it would mean.
Interesting.
I think that's the great unknown at this point.
And I think I like the final question that I have on kind of private trials is, what's the mechanism? Who has the authority to swear in the witnesses, for example? Who would do that?
I would think the judge. Honestly, I don't see a problem with a judicial officer swearing. I frankly, I don't know about my colleagues, but I've been put in positions where I'd have to swear bailiffs to take charge of jurors when a bailiff has to go. So I'll swear. I swear people all the time.
Yeah.
That's swear an oath. Is that not swear at?
Well, it depends on the issue, but yes.
The rules actually provide for a clerk of the court. But we've all had instances where the clerk is trying to do something else and will just swear a witness in so that the clerk can manage some exhibits or do something else in the middle of a trial. So that's an easy issue.
So at ARM, because I had a brief look at the the rules, I think you probably need a clerk that take custody of the exhibits and stuff like that. If we're providing staff for that, can the judicial officer swear in that staff member to be the clerk, or like how does that work?
Well, that's again another question that would be, at least if I were convening a private or alternative trial, that would be first and foremost with my counsel. How do you, what are you going to agree to on this? What is going to become the official record? I firmly believe that by agreement, I think as we've all mentioned, so long as the parties agree, you can do just about anything. But so long as the parties would agree, and there would be a mechanism to maintain the exhibits in an appropriate way, I think a staff member could handle that, yes.
I think it's probably a really prudent thing that when parties, obviously all three of you could and would be very great jurists for a private trial. I mean, I think a prudent thing to do is, if you're stipulated to, the first thing you would want to do is have status conference where you kind of hash out all the details, get them stipulate to it so that, they can't wiggle their way out of it. That's not what I agreed to. You want it set in stone. This is what we want. And we both agreed to it, right?
Like
Yes.
a free art. Yeah.
Excellent. Okay, I mean, that's really, really useful. And I think from a litigator's point of view, this is something that I think most litigators should be thinking about, because Nevada is in a very, very unique position, because in California, they don't have a rule like this. In most jurisdictions, they don't. The best they can do is stipulate and go and do an arbitration. And I think it's a very, very useful tool that is that is very much underused. And I think the insight that you've all provided is actually going to be invaluable for all the litigants. Doesn't matter what area of law you practice, as long as you're in litigation. I think you guys have provided a lot of really, really useful information. Would it be okay if anybody has any questions to go through your case managers to contact you with any further questions if they inquiring or anything like that? Please send an email to Amy at armadr.com, and she'll forward to the judges any questions that you may have, and they'll be, I hope, happy to respond in case you have any inquiries. Any final thoughts before we get going?
No.
I would certainly encourage everyone, whether just as a result of the health situation or in the future, to take a look at this unique rule and to use it. I think that it is a benefit to all litigators in most type of cases. And I think that it will be certainly of value to your clients in your practice.
Thank you.
Agreed.
Well, judges, thank you so much for your time. Really, really appreciate it. And please stay safe, please stay healthy, and continue the good work. Take care.
Well.
Bye now.
Bye.